I would say it's partly a joke and partly not a joke. In the question of preliminary reference, as in the question of judicial review, one can say that one shot is enough in some cases, and it's not necessary to have the repetition of the same cases. Sometimes one decision is so important that one shot is enough. But in the same times, we know, we have discussed, I remember here with Pasquale about Japan, when the number of decision striking down or setting aside statute law is very weak, the remedy and the arm of judicial review is also weak, because if it is only a threat which is never used, of course it can have a dissuasive effect towards the parliament who makes some efforts to have statute laws not likely to be challenged before the court, of course. But again, if there is a very small number of cases, I could consider that it is something exceptional, and for this reason, not so important. And it will be important, especially for this mechanism of international review of the statutory law in comparison with international norms, to have statistics in France, in Netherlands, and in other countries that are knowing this system, to evaluate it.
But the difference is that now there's not even an investigation if there's a constitutionality. So there's not even the investigation is not even being held, even if it would be put aside or not put aside. It's just not being held. So one of the main arguments that was also brought up, what is the added value, especially with already having international treaty review. Why would we even want to have the constitutionality review? And so she doesn't really give any specific statistics, but she raises certain specific examples which could have an influence. And especially one of the importance of the constitutional review, instituting it, she says, would kind of reinvigorate the importance of the Constitution. Because right now what you see is even when there can be constitutional review of secondary legislation, it's often not done because people have to lawyers are more common to refer to the convention. So that's one of her arguments of the Halsema proposal, at least, to instate constitutional review.
May I link this question with a more general remark and a question for the fact that courts, especially high courts, strong courts, could interpret the statutory laws as they want, giving them their own meaning, could have not exactly the same outcome that judicial review, but something comparable with judicial review. And perhaps one reason or one factor among others to explain the transition from this old judicial power to the new perspective of judicial review. But there is a great difference in France, but also in other countries, and you have said also in Scandinavian countries, the fact that old courts in the Ancien Régime, and even in some countries in the first half of the 19th century, did not give and publish the reasons of their decision. And for this reason, the case law about the interpretation of statutory laws and the possibility of through a new interpretation to completely change the content of the statutory law had a weak impact because, except for the judges who have decided the case, and probably some persons informed about the decision was not known. It was not known by the inferior courts in the absence of a law report, and a question for which I am sensitive as a legal historian. When something is not published, it could be known in the present generation, but it will be forgotten in the next generation. And probably we have forgotten, Mals has explained to you that we know, thanks to Norwegian works, that there were cases of judicial review in 1845 and 1866, and you are saying, no, before there were other cases, but without reasons, not published. And perhaps this argumentation could be used in other countries. And here, I think it's a discrepancy between old forms of judicial reviews without reason, without publication, and for me that means with a limited impact. I don't say a null impact, but a limited impact, and the new form of judicial review, which is also linked with a general movement, the same times in civil law and in common law countries, to publish regularly the decision, to have precedence. We know also that in Great Britain, the true rule of precedence is not a Middle Ages creation, but something linked with the law reports of the 19th century. And of course now, the problem is not exactly the same, because not all, but many decisions are published through law reports or through internet. But the Dutch example and the French one, that we don't know how many cases about setting aside a national law, a domestic law, inconsistent with international treaties, shows perhaps that it remains a kind of opacity and absence of knowledge about how it works in practice. And the outcome is not so different from the situation of the past, where this opacity and this absence of knowledge was linked with the absence of reasons and the absence of publication. And it means also that, on this question, like for others, we have a small knowledge of all the reality of the case law. I don't speak in ontologic perspectives, and that this strong knowledge we have has effects to perhaps over-evaluate differences which do not exist, or under-evaluate differences we don't see, but what exists in fact. And would be pleased if, according to your national system or the system you have studied, you could explain your opinion about this point. And my last remark, I don't want to abuse, is that intervention and every speaker has shown that today we can see like a kind of renationalization of judicial review. Something which can seem as an argument against the advocates of supra-constitutionalism or constitutionalism beyond state. Perhaps our period is not the one of a complete decline of the states, of the national states, and of the complete triumph of supranational organization. On the contrary, and with the crisis, there are trends to new forms of nationalism and renationalizing judicial reviews, and it means that also the differences can be more and more important between the different states, including the European states. Every state developing a specific way with the political context. The fact, for example, that Scandinavian courts could use now the international covenant about economic and social rights to defend the social state created during the 20th century is something new and which could not be foreseen. Of course, the writers of the United Nations Covenant are not the idea to protect social states in Northern Europe through this covenant. And it has been said that this covenant was a compromise between socialist countries and liberal countries in the United Nations. And now it can be, in a national context, perhaps for a small time, we don't know, reinterpreted as a means to define what is considered as important in the national context, but what is not in the national constitution.
Yes. Well, I had questions, but there are so many points also that could be discussed here, but interesting points and extremely interesting your intervention. And I find this indeed quite peculiar, the way the situation you describe about treaties being, the legislation is reviewed with respect to treaties, but not with the constitution. So I'm curious to understand the relationship between the treaties and the constitution, because the Netherlands constitution has got a relatively modernized human rights chapter, if I recall correctly. I mean, it's all the rights are there, and there are more rights than in the European Convention on Human Rights. There are more social references to social and economic rights. So the question is, are they, the constitutional rights, are they not applicable at all? Are they not referred to, or do they not, do individuals not rely upon those provisions? Do they focus on the European Convention? That's one question. Another question is, since treaties have this special status, is there a difference in how treaties are implemented? I mean, are some of them classified as self-executing, whereas others are not? I mean, treaties such as the Covenant on Economic, Social and Cultural Rights, which is, well, at least by some considered to be containing non-self-executing provisions. Has this treaty ever been the reason for a legislation is being set aside in the Netherlands? Do you know that? Or are all human rights treaties treated equally in that respect? That's really important, because if these treaties, all these open-ended treaties and the progressive rights and more in a declaratory way instead of being civil and political rights, if they are setting aside legislation in the Netherlands as the European Convention on Human Rights, how is that really functioning? And where do we come then to the question about the political power and so on. So that these are the points I would like to mention. Also, now let me see. Where was I now? Yeah, I think that we could do for at least for the moment. If you could, maybe you could comment on that, and maybe we could comment on very many other good points later on. Yeah.
Before answering, I want to add one question to you, and I want to take advantage of the fact that you are not only able to speak about Netherlands but also about Belgium. So my question is the following. Both the Belgian Constitution of 1831 and the original Dutch Constitution of 1814 were written under the strong influence of the French Revolution legal culture. So in both these constitutions, judicial power was clearly subordinated. It's more emphatically so in the Dutch Constitution, which is the only one in the world, to my knowledge, which claims that judicial review is unconstitutional, less so in the Belgian one, but I mean, they come from the same tradition. Now, I want to know more why Belgium deviates from this Jacobin tradition and established first a Cour d'arbitrage, and then later on a very important constitutional court, which has been of great inspiration from the French. French do not like to say so, but they almost copied the Belgian model of with the reform in 2008. So what happened? Why this bifurcation coming from the same tradition, notably taking into account that Belgium is not a post-authoritarian political system. So it's very easy for me to explain why Italy or Germany or Poland or Hungary have judicial review, I mean constitutional adjudication. But Belgium has nothing to do with a fascist regime becoming a democracy or a communist regime becoming. So it's a very important case. Like all these Northern European, I will come back to that in my final remarks if we have time. But I mean that's my question. Can you tell? I suppose that's just a guess that it has to do with the federal structure. The first original rules of judicial review, which is more important than rights. Federalism is the origin of the story. Now, that I want to add that it's interesting to compare Belgium and Netherlands and the United Kingdom from a different point of view. From the point of view of the relationship between internal constitutional law and international treaties. Because it seems to me that these three countries have been following three different paths. In Netherlands, they have been saying so far that what Guy Carcassonne told me 4 years ago, we don't need to modify the constitution because we have the control de conventionnalité. We can do everything. Then he was member of the commission introducing the question préliminaire de constitutionnalité, but that's a different story. So, I mean, one option is to say, well, what do you want? We have the control de conventionnalité. We don't know anything about that. A footnote, I mean, I completely agree with Jean-Louis. We know a lot about doctrinal debates, we know a lot about political debates, we don't know much about law, real, the droit. We know a lot about speeches, you know, but what judges do, we are still most in the darkness. Okay, so, but one option is the Dutch option. The second option is the UK, which wants to bring rights home. And the third option is the Belgium, which creates a constitutional court. So these are three models of coping with this double hierarchy of norms. I would use this language. But can you tell us a bit more about the Belgian Cour d'arbitrage and Constitutional Court?
Yes, I can. And
I
as
know
you,
that you can. That's why I asked you the question.
But you said it perfectly. I mean, it started with Belgium moving from a unitary state to being a federal state. And so
When was the Cour d'arbitrage introduced? I don't remember that.
in 1980,
So recently.
83?
Well, fine.
Beginning
Doesn't
of the
matter.
1980s.
Yes, okay. So it's
Uh,
pretty recent.
Yes, and then so what happened was in the beginning they only had the power to adjudicate conflicts of competence, which was the reason why, that's why it's called
Arbitrage.
arbitrage, is because it was an arbitration court seeing, you know, which, if because it was necessary, because what if one of the regions would overstep their boundaries in making a decree, then,
It's a
you know,
federal court.
so, but then what happened was there was another state reform, and then in 1989 the arbitration court, and still called that way, got the competences of Article 10 and 11 in the Constitution, which is the discrimination clause and equality clause, anti-discrimination clause and equality clause, and together with the right relating to Article 24 of the Constitution. But what is essential to Article 10 and 11 is that it wasn't intended to create sort of rights adjudication for the Constitutional Court. It was, again, sort of a compromise to deal with federal issues. But what happened is that the court started constitutionalizing almost any international right. What they said was that it's a general clause, it's a general equality clause. So every time that someone's right is being discriminated, no matter what right it is, in what international treaty it's protected, for mainly the European Convention on Human Rights, we will evaluate it and see if there's discrimination. And so they pretty much constitutionalized the European Convention on Human Rights and also a lot of other different treaty provisions. So that's what happened is, and then they did that also with the kind of legitimizing power of the European Court of Human Rights. So they used a lot of their case law to kind of strengthen their case law, because the political, there was a lot of the same kind of things that you see in the Netherlands with the scare of sort of judicial tyranny and these kinds of arguments. And so slowly the arbitration court developed into a constitutional court, and the political arena kind of accepted it. What was more difficult was the other courts. There's a very big kind of, I wouldn't call it battle, that's too extreme, but a very kind of a conflict between the ordinary courts, administrative courts, and then on the other hand the constitutional court, because the Cour de Cassation and the administrative courts have the power to do treaty review.
Yeah,
And then all of a sudden the Constitutional Court is pretty much doing treaty review and constitutional review. Because then with the last reform, the political debate, they said, oh, well, you know, things are going well, so we will give you the right to review all constitutional rights as well. So now they interpret constitutional rights also an analogy with, together with the analogous rights protected in the convention, mainly in the European Convention on Human Rights. So they do both of them, so it's more of a conflict, I think, but that's how it slowly evolved into a constitutional court. So that's the main, that's also why I emphasize a sort of lack of constitutional moment in the Netherlands, is that they didn't have that shift to federalization with then kind of an accidental equality clause coming in, which, I mean, the first judgment that the Cour d'Arbitrage, after getting that competence, the first judgment they made, they applied that equality clause in a way broader sense than was anticipated by the politicians.
Just an historical remark, the very strong power conferred to the Cour de Cassation in Belgium since 1831 Constitution, the first Constitution, is the first bifurcation from the French tradition. Of course, the Belgian Court of Cassation is imitated from the French model, but a stronger model of a kind of judicial power, more than in France. Taking account, of course, of the importance of case law and jurisprudence in France, even in the 19th century. But at this time, the birth of the Belgian state, there was, seems to me, a first bifurcation from the French model in establishing a strong court of cassation with even political powers. There's the possibility to judge ministers or to have political process in the Belgian Court of Cassation.
Do you want to address your question?
Yes. Then with
Relationship
all the convention
Yeah.
ratified in the same manners.
oh yes,
Become-
but well, the thing is, it's a monist system. So as soon as there's a treaty that's been ratified, but as I told you, in 1956 they added this binding on all persons. And so, as you can see, for instance, in the Halsema proposal, I can show you later on if you're interested, the rights that they're putting forward to have constitutional review over are the clear political, civil and political rights. So there are about 3 provisions that offer clear social rights, and they're not.
They're excluded.
They're excluded. So there's one on welfare. There's one on I think environment. I think one is. So they're excluded, and also. All the case law I've read, it's always, I mean, the main document has always been the European Convention on Human Rights, and also a little bit less the International Treaty on Political and Civil Rights.
This means that they select the provisions and the conventions which they consider to be binding upon in
They don't really
relations.
select it, but they make comments as in that does not fall within Article 94. It's not direct. It's not binding because it needs to be directly applicable. So when there's problems with that, they don't use it. And they're also very kind of.
Are they ratified as an act? The treaties, they do
Yes.
receive the same
Yes.
procedure as an act, so they are ratified through 3 or how many discussions do we have per bill?
2.
Yes, so it's just handled the same way as every other act when you ratify a treaty. So
Yes.
yeah, but without the
So, but
possibility.
once that has happened, it's binding. It has the
Okay.
power of being in the hierarchy of norms. It's above the Constitution. But it might not be able to. There might not be treaty review on all acts that are above the Constitution if they're not binding.